Hi, thank you to those who are coming in. We will get started in a few minutes. We'll wait a few more minutes and then we will get started. All right, we will go ahead and get started and let folks continue to trickle in. Thank you everyone for joining us tonight. This is a webinar for decision-making tools on finances using the information from CCE's Community Education Guide when adults need help. So the Council for Court Excellence is a nonpartisan, nonprofit civic organization. My name is Casey Anderson, and I am the communications manager. As a catalyst for change for nearly 40 years, CCE has worked to improve the district's justice system by collaborating with diverse stakeholders to conduct research, advance policy, educate the public, and increase civic engagement. Among other educational efforts, CCE has published and distributed over 300,000 copies of plain language booklets, guides, and other materials explaining various areas of the law and court processes in the District of Columbia. Electronic copies of these guides are available on CCE's website. CCE and Quality Trust, along with other interested organizations such as AARP's Legal Counsel for the Elderly and Disability Rights DC, at University Legal Services, collaborated to produce a guide for the public entitled When Adults Need Help Making Decisions and Managing Daily Affairs, a non-lawyer's guide to DC's legal tools for assisting adults. The guide has two overall goals: to be comprehensive. It covers not only traditional and more familiar legal tools in this area, such as guardianship, conservatorship, and power of attorney, but also less well-known alternatives, such as supported decision-making. It's also supposed to be easily understandable for non-lawyers. So to the extent possible, the guide avoids technical terms and is written in straightforward, plain language. This webinar is an outgrowth of CCE and Quality Trust collaborative efforts on the guide. And so although CCE's guide covers the full range of adult supports in DC, health, financial, education, the focus of this webinar is on financial decisions.
Good evening. My name is Morgan Whitlatch, and I'm the legal director at Quality Trust for Individuals with Disabilities. Quality Trust is an independent nonprofit advocacy organization that's dedicated to effective advocacy and legal representation for people with disabilities. For nearly 20 years, Quality Trust has worked to improve the lives of children and adults with disabilities and their families in the District of Columbia. Quality Trust Jenny Hatch Justice Project is dedicated to advancing the decision-making rights of people with disabilities and helping them avoid undue or overbroad guardianship. We provide legal assistance to DC residents who have questions about their decision-making rights, or are in a guardianship that they're unhappy with, or who want to explore less restrictive forms of decision-making support, such as supported decision-making agreements, powers of attorney, advanced directives, and other legal options we're going to be talking about today. Next slide.
Hi, everybody. My name is Catherine Yergu. I work at Legal Counsel for the Elderly. For more than 45 years, Legal Counsel for the Elderly has championed the dignity and rights of Washington, D.C. elders by providing free legal and social work services to those in need, both empowering, defending, and protecting them. Legal Counsel for the Elderly provides a wide range of civil legal services, from assistance with eviction prevention and home ownership preservation to public benefits and wills and powers of attorneys. Legal Counsel for the Elderly also houses the Long-Term Care Ombudsman and the Senior Medicare Patrol. Next slide.
You're muted, Casey.
I realized, thank you. So tonight you will hear from both Morgan and Catherine, and I just want to say thank you to both of them for all of your hard work on this webinar series and being here tonight.
So we're going to be covering a range of decision-making tools in this webinar. Sorry about that. We're going to be covering a range of decision-making tools in this webinar. The list that we have goes from the least to the most restrictive legal tool. So supported decision-making, financial powers of attorneys, management of federal benefits, other financial tools, and then last, guardianships / conservatorships. We're going to focus a lot on supported decision-making, which is the newest and most flexible tool to assist people. In the right circumstances, it can be really effective. It's very flexible, and you won't have to use a lawyer or involve the courts, unlike some of the other options. It avoids the restrictions on personal autonomy and the rigidity of the traditional tools of guardianship and conservatorship. It's therefore more consistent with the overarching principle of DC law that supportive arrangements allow the greatest degree of self-determination possible. This is consistent with the mental and physical limitations of the person needing help. Next slide.
So what happens at 18 years old? The age of majority in DC is 18. And what that means is that when a person turns 18, they're considered an adult, and they're presumed by the law to be able to make their own decisions, even if they have a disability. And there's a really strong statutory presumption of capacity in DC. Under the law, an adult 18 or older is presumed competent and to have the capacity to make legal, healthcare, and all other decisions for himself or herself or themselves, unless certified otherwise under the DC Healthcare Decisions Act, which is a tool we talked at our last webinar, or deemed incapacitated or incompetent by a court. Under the law, incapacity shall not be inferred from the fact that a person has been hospitalized for mental illness or has an intellectual disability. In the past, when an adult with a disability, including those that are age-related, needed support with decision-making, their traditional advice was to go to court and to seek a guardianship, even when all the restrictions and protections of guardianship were not necessary. Now, however, there are less restrictive, less formal, less expensive options that we really encourage to be explored first. Next slide, please. And the first of those, or the least restrictive, is supported decision-making. And what is supported decision-making? On its most basic level, supported decision-making refers to a common everyday practice with which we're all familiar. That is asking for the advice or thoughts of another person or persons before making an important decision. It's given a special name in the context of people with disabilities, including those that are older adults, to remind us that just because they may need more or different kinds of help in understanding the decision to be made, it does not mean that they're automatically incapable of making the decision themselves. In this way, supported decision-making can be seen as a reasonable accommodation for a person's disability. Supported decision-making refers to a really broad range of arrangements that enable people to obtain the guidance and support that they need without giving up their legal right to self-determination. For example, they can choose one or more trusted family members, friends, or advisors to provide them with help in understanding, making, and communicating significant life decisions while retaining the right to make those decisions for themselves. And studies have shown that people with disabilities and older adults who have more self-determination, that is, they're more able to directly control their own lives, usually have better jobs and a higher quality of life. They're healthier, they're better problem solvers, and better able to fend for themselves and avoid abuse. Supported decision-making has been acknowledged by the American Bar Association and the National Guardianship Association, among others, as a really helpful tool for individuals who need extra help to make or communicate their decisions. And in May of 2018, the District of Columbia became the 4th jurisdiction in the United States to enact legislation that expressly recognized supported decision-making agreements. These agreements can now be used across the lifespan and in all life areas, including finances, which is our topic for today's webinar. Every person, institution, or agency in DC must honor a supported decision-making agreement that conforms with the requirements of the 2018 law, unless it has good reason to believe that the person needing support is being abused, neglected, or exploited. Next slide, please. So we're going to talk a little bit about the steps to establish a supported decision-making arrangement, and we'll talk more about the specific DC form in a moment, but let's first talk about the basics of a supported decision-making arrangement itself, regardless of whether or not it's formalized in paper. There really is no one-size-fits-all for supported decision-making. Supported decision-making, regardless of whether it's used in the financial context, is going to look different for different people. After all, people have different needs and different support networks. People have different ways of communicating. The key question is, what will it take to successfully support the person with a disability or older adult? And it's critical that supporters work with the person and identify where help is needed and how to provide that help. Supporters do not make decisions for the person with a disability or older adult. Instead, supporters help them make or communicate their own decisions, such as how to spend their own money, how to budget, how to save, how to make sure that their bills and taxes are paid, and more. Supporters may also explain the choices the person faces in more easily understandable ways, ask questions for the person, help the person gather information, or assist with the person's communication to others. The supporter should be an adult that the person chooses, that the person trusts, someone who wants the person to be able to make their own decisions and who wants to act in the role of a supporter, who doesn't want to make the decisions for the person, but to support the person in making their own decisions. They should be trustworthy and reliable and not likely to hurt or exploit the person in some way. Next slide, please. So what is a supported decision-making agreement when we talk about finances? Really, a supported decision-making agreement, it's a way of formalizing a supported arrangement in putting it in writing. Okay, so you can use supported decision-making formally or informally. If you're going to put it in writing within the context of finances, you're going to be using a statutory supported decision-making agreement form, which was what was put into the law in 2018. CCE's guide, When Adults Need Help, contains information on how to get an electronic copy of the statutory supported decision-making agreement form. Next slide, please. Now, one important thing to keep in mind when you're using a supported decision-making agreement to formally record an arrangement involving supported decision-making is that the law does have special rules for who can be a formal supporter. Under the law, certain people can't be a formal supporter under a supported decision-making agreement that includes support for financial decisions. And there are two types of restrictions. The first restriction is on this slide, and it applies to people who are connected to certain governmental agencies or providers who are not relatives of the supported person. So a formal supporter who is not a relative of the person cannot own or operate any entities that provide disability or healthcare services to the supported person. A formal supporter who's not a relative of the person also can't work for a governmental agency that's financially responsible for the supported person's care. So depending on the person, that could include, for example, employees of Child and Family Services Agency or CFSA, or DC Healthcare Finance, which is DC's Medicaid agency, or the Department on Disability Services. But remember, these first type of restrictions do not apply if the supporter is a relative of the person. So you could be an employee of the DC Healthcare Finance Medicaid agency and still be a formal supporter for someone who receives Medicaid, provided that you're related to the person, you're a relative of the person. So that's the first restriction on who can be a formal supporter under a statutory supported decision-making agreement. Next slide, please. The second restriction on who can be a formal supporter under a supported decision-making agreement for finances has to do with illegal or wrongful behavior. And these apply even if the formal supporter is a relative of the person who needs support. So the general rule is that they cannot, one, have been found by a governmental agency to have abused, neglected, or exploited the supported person, or inflicted harm upon a child, older adult, or person with a disability. And two, a formal supporter cannot have within the last 7 years been convicted of certain crimes, including sexual offenses of aggravated assault against a child, older adult, or person with a disability, fraud, theft of $1,000 or more, forgery, or extortion. So the big exception to the second restriction on who can be a formal supporter is that these background requirements do not apply if the supported decision-making agreement is for educational decisions only. But guess what? This webinar is about financial decisions, not educational decisions. We did that one 2 weeks ago. These background requirements do apply to formal supporters within the financial context. Next slide. So how do you make a financial statutory supported decision-making agreement? We're lucky because we have a form now. So first you use the statutory supported decision-making agreement form, and Quality Trust collaborated with the Department on Disability Services to create a plain language packet that contains the statutory form along with helpful information and instructions on how to complete it. And you should read those instructions really closely because they have a lot of the requirements we're talking about now about who can sign the form and who can be a formal supporter. And that particular packet is linked to in the CCE guide. So for financial decisions, what you would do is you look at the form, and this is a picture of the first page of the form. And you could circle yes to pick a supporter in applying for and maintaining supports and services, including district governmental assistance. You could circle yes if you needed a supporter to help manage your financial affairs. And you could do yes if you wanted to manage real property transactions. You could also enter in if you wanted support with other kinds of financial transactions. Okay, so it's designed to be a kind of easy to use, circle the yes or no or enter what you want kind of form. Under DC law, the supported decision-making agreement has to be signed by both the supported person and the supporter. And they have to sign it in the presence of either a notary or 2 witnesses, but it's good practice to use both. And if an individual wants multiple formal supporters, each supporter would need a separate supported decision-making agreement. So say that I had 2 people who were my supporters for financial decisions, I would be signing with that supporter, with each supporter, a total of 2 agreements. Next slide, please. So what do you do after it's signed? The person with a disability should give a copy to their bank or other entities that need to know about the presence of a supporter. The great thing about the form is you don't need a lawyer to complete a supported decision-making agreement form, and you don't need to have a court approve it. The supported person or the supporter can cancel or change the supported decision-making agreement at any time. That cancellation or change should be done in writing, and copies should be given to anyone who got a copy of the original supported decision-making agreement. It should also be given a copy to the person with a disability, who should actually be the one to keep the original, and the supporter. Next slide, please. That was just an example of the formal supported decision-making agreement, but there are other supported decision-making options for financial matters in DC. For example, Iona Senior Services administers the DC citywide money management program. The DC Office on Aging, Legal Counsel for the Elderly, and other organizations can help people apply for this program. But there are certain eligibility requirements to use it. To be eligible, the person needing help has to reside in DC, so it can be at any of the 8 wards in DC. They have to be at least 60 years old. They have to be affected by dementia or memory loss, and they have to have an annual income of less than $54,250. So it's that's subject to change, that particular amount, but they have to make less than a certain amount of money to be eligible. Iona social workers make regular home visits. They review mail, they help organize finances, they help with budgeting and making sure bills get paid on time. They can accompany clients to the bank or the ATM, and they can review financial statements. So they're providing kind of supported decision-making services through this program without the need of a supported decision-making agreement, because it's a program. And program participants are not charged for those services. And while they're receiving that kind of support, those program participants retain control over their finances, and they can withdraw from the program at any time. So it's a voluntary program to be involved in for those people that need that kind of support. Next slide, please. So we've kind of talked about this. Let's get kind of nitty gritty and actually provide a kind of hypothetical or example of supported decision-making in finances. So Jordan is 65 years old. He lives in subsidized housing. He has limited Social Security benefits, and he is experiencing memory loss. Jordan is capable of paying his bills, but he gets help from a social worker at Legal Counsel for the Elderly because he knows he spends too much money shopping sometimes. His social worker connects him with Iona Senior Services so that he can join the citywide money management program. Each month, Jordan meets with his money manager to review his budget and pay his bills using supported decision-making. Jordan also picks a trusted friend to appoint as his financial agent under a power of attorney in the event his memory loss becomes more pronounced. And so that in itself is an example of how powers of attorney, which we're going to talk about in a moment, and supported decision-making can kind of be used in tandem, right? They can kind of support each other. So Jordan is planning for the future in the event his memory loss declines to a point that he is no longer able to make his own financial decisions, even with support. While until that point, he's getting the support he needs to be able to make his own financial decisions. So we're going to be turning to powers of attorney next, but I think it's really important to really know here that supported decision-making agreements and arrangements can be used in tandem with some of the other tools that we're talking about today. Next slide, please.
Thank you, Morgan, for that lead-in. We're going to be talking about financial powers of attorneys now. A power of attorney is a legal document that allows a person, and we call that person the principal, to appoint a representative called an agent or an attorney in fact, to act on the principal's behalf in financial and everyday matters, pretty much everything that doesn't involve healthcare. It is different from supported decision-making agreement because the agent, unlike a supporter, can make the decisions for the individual without the individual being there. Despite the terminology, the attorney in fact part, you don't actually need to be an attorney or a lawyer. You can appoint a family member, a close friend, a trusted advisor, or any other trusted adult to serve as your representative. When you establish a financial power of attorney, you're giving someone else the authority to make important and sensitive financial decisions on your behalf without any review or supervision by the courts. Giving somebody that level of power can have serious consequences. So it's very important to make sure that the person you're giving that power to is completely trustworthy and reliable, that they have sound judgment, that they have the time, the availability, the capability, and the desire to fulfill the responsibilities described in the financial power of attorney. It's important to understand that they understand your wishes and are willing to follow them. So before making someone your financial agent, you should discuss your preferences and wishes with the agent to ensure that they fully understand what's going to be happening and they're willing to comply. It is, I can't stress this enough, it is incredibly important that the agent agrees that they want to help you, because it doesn't make sense to make the document if they're not willing to assist. A financial power of attorney authorizes the agent to do a lot of different things. You can apply for a health benefit. They can manage the principal's business. They can manage the banking transactions. They can help with taxes. They can buy and sell real estate if specific language is added for that. So it's really a wide range of things, not just what we would consider financial matters. It's things like transportation, and all those things are also included in a financial power of attorney. So it's everything except for healthcare decisions, really. So when you make them, you want to make sure the document accurately and clearly expresses your wishes, and that it addresses all potential contingencies and consequences, and as well complies with DC law. Next slide. So I mentioned a whole bunch of things, and that's to just elicit the fact that the financial power of attorney is a very specific document to establish very specific goals for the principal, and it can be tailored to different situations. You can have a power of attorney that is very limited to particular duties that the agent completes. For example, if you just want somebody to help manage the real estate, your house, you can have the agent just have that on the power of attorney, and that's all they're going to do. Or you can have a very general financial power of attorney that covers everything except for healthcare decisions. You can have a power of attorney that is limited in time. And so it's only going to be effective for a certain amount of time. For example, my dad travels a lot, and so he made one for that time period that he was traveling so my brother could handle his affairs. But it cancels out at the end of that time period. You can also have it effective at different times, and this is where it becomes a really good match with supported decision making. You can have a financial power of attorney that's effective immediately, so that the agent steps in and can start acting on their own right away. Or you can have a financial power of attorney that's only effective upon a certain triggering event, and that's what's called a springing power of attorney. Usually, especially for seniors, what we do is a springing power of attorney when they lose capacity or when they're no longer able to make decisions for themselves, then the power of attorney can step in. Before then, they can have a supported decision-making agreement that allows somebody to help them. They still get control while they're still able to make those decisions themselves. And when they lose capacity, the power of attorney is there to protect them from having to go through conservatorship or guardianship, which we will talk about in a moment. Next slide. DC law provides a form for creating a financial power of attorney, and the CCE guide contains a link to that form. There are certain requirements in making a financial power of attorney. The person granting the power has to sign the power of attorney while they have the mental capacity to do so. If they want to change it or cancel it, which is called a revocation, they can do that at any time. They just have to still have that mental capacity. Any changes that they make have to be in writing. And if they are canceling or making changes, they need to make sure that everybody has a copy of those changes. The law requires the power of attorney to contain specific elements, such as notarization, in order to be legal. You should always have a lawyer draft or review the financial power of attorney. One thing I will say is that each state has different rules about financial powers of attorneys. We're talking about DC, but many people end up crossing to Maryland or Virginia for different reasons. And so what we always recommend people do is have it notarized and also signed by 2 witnesses. The reason is Maryland requires 2 witnesses, and it'll be a lot easier to go to Maryland for example, if somebody has a nursing home stay there, or you just have some business in Maryland, that power of attorney will be more easily accepted if their witnesses are also on there. If you do use witnesses, the witnesses should not be the people named as agents, and preferably not family members either. It's best to have people who are not involved in any financial decisions be witnesses. Next slide. So how is a power of attorney different from a guardianship? With a power of attorney, the person seeking support decides what power to give and who gets it. That's not the case for guardianship. Power of attorney can also be changed or canceled without going through the court. So it's a less restrictive tool than guardianship or conservatorship, but it is more restricted than supported decision making. The individual, if it's effective immediately, the agent can act without the individual right there. Next slide. So we have an example here. Mohammed was recently diagnosed with brain cancer and is scheduled for surgery. Mohammed creates a uniform general power of attorney that grants his mother authority to make property, banking, and other financial decisions on his behalf if the operation leaves him unable to do so. Mohammed trusts his mother to take actions consistent with what he would do himself. He makes sure to keep the language in the DC law, the DC form, making the power of attorney durable so that it stays in force even if he becomes disabled, incapacitated, or incompetent. While recovering from surgery, Mohammed is unable to communicate or understand information. During this time, Mohammed's mother pays his rent by writing checks to his landlord from his checking account. When Mohammed regained his ability to communicate and to understand information, he cancels the power of attorney. So this is a great example of how powers of attorneys can be used to protect somebody while they're having incapacity. You don't have to go to the courts. You can just have this document. You've already established who's going to be there to help you. And once you regain the capacity, it gets canceled and you're back to doing things the way that you would normally do. Next slide. So the financial power of attorney is a great tool, but it is not accepted everywhere. The federal government does not accept financial powers of attorneys, which means if you receive federal benefits, you'll have to use other tools if you want some additional assistance. So when a recipient of certain federal benefits needs help paying bills, balancing expenses and income, and otherwise managing those benefits, the federal government can appoint a person or organization to serve as a representative payee or a fiduciary to handle the benefits on their behalf. There are 3 types, and they're listed there. There's the Social Security benefits, there's federal employee retirement benefits or civil service, and there's veterans benefits. This is a process that you have to go through with each agency that you are dealing with. Next slide.
So let's turn to representative payees for Social Security benefits. In this context, representative payees are for beneficiaries of Social Security who cannot manage or direct the management of their own benefits. So it's the Social Security Administration that is the agency that appoints the representative to act for the person in these circumstances. You do not need to be a guardian to be someone's representative payee, to apply to be someone's representative payee. The Social Security Advisory Board advised the Social Security Administration to rule out the possibility of supported decision-making before appointing a representative payee. And I'm doing my little plug here, okay? Not everybody who has a disability or who's an older adult needs to have a representative payee. Some of them can manage their own benefits or direct the management of their own benefits with support. To become a Social Security representative payee, the individual or organization submits the documents and is interviewed by the Social Security field office. An application form is available on the Social Security Administration's website, Form SSA 11. You also need proof of identification, the applicant's Social Security number or employee identification number. Actually, the form is no longer available on the SSA website. Sorry about that. You must call to get a copy of that mailed to you. And then you also need to submit a physician's medical certification stating that the benefit recipient is not capable of managing or directing the management of benefits in his or her best interest. Or you need to submit proof that a court has appointed the applicant to serve as guardian of the benefit recipient. But it's not enough just to be appointed guardian. You actually have to go through the application process if you want to manage the person's benefit. Before the current pandemic, the Social Security Administration interview was required to be in person at the Social Security Administration field office. At this time, however, SSA staff are working remotely and conducting business by telephone. So I've seen people apply through an interview on the telephone to be a representative payee. Once again, being appointed a guardian or conservator by a court or appointed as an agent by a power of attorney does not entitle a person to serve as a representative payee for another person. It's a separate application process, and it has to be approved by the Social Security Administration. There are important rules that representative payees have to follow. When they serve in this capacity, the representative payee is responsible for managing the payments to meet the current and future needs of the person, such as housing, utility, food, medical expenses, personal care, clothing, transportation. The benefits have to be used for the benefit of the person who is the beneficiary, not the representative payee. The representative payee should keep records of the benefit payments received and spent. They may be required under certain circumstances to submit annual reports to the Social Security Administration. As a result of a recent change in law, the Social Security Administration is no longer requiring annual reports from certain payees, including spouses of beneficiaries and the natural and adopted parents of adult beneficiaries with a disability who reside in the same household. For additional information on the Social Security Representative Payee Program, we encourage you to look at the CCE guide, as well as some of the resources that are linked to in the CCE guide. It's a big responsibility to be someone's representative payee, and we really encourage you to keep that in mind in making that kind of consideration. Fraud by a representative payee is a federal crime subject to serious penalties and can be reported using a fraud hotline. If a beneficiary does not want a representative payee anymore, the beneficiary has to show evidence to the Social Security Administration that they can now manage or direct their own benefits. And making such a showing usually requires the submission of a physician certification form or other kind of evidence. So the person does have a right to challenge the appointment of a representative payee. To be successful, it usually requires evidence if the representative payee is already been appointed. Next slide. So let's kind of discuss a concrete example of a representative payee for Social Security benefits. Lena, who receives Supplemental Security Income or SSI, has dementia and might get evicted from her apartment for not paying rent. She does not have anyone to handle her finances, and she says that she no longer understands her financial situation, even with support. Lena goes to Iona Senior Services and fills out the papers to make it her representative payee. After that, Iona Senior Services helps Lena pay her rent every month so that she can stay in her apartment. So, representative payees are a really good option as an alternative to guardianship for people who only have Social Security benefits. They can be a really good option. In this case, and this example illustrates that. Next slide, please.
So the Office of Personnel Management is the one that handles the federal retirement benefits, and they will make federal retirement payments to an approved representative payee responsible for managing the funds on behalf and for the benefit of a retired federal employee, who they call an annuitant, who lacks the capacity to handle the money on his or her own. It's a different process. It's only a court-appointed guardian or conservator or other approved representative payee is allowed to handle the benefits of an individual. And that's with OPM's approval as well. So a family member, friend, or organization that wishes to serve as a representative payee has to submit a completed application form to OPM. The link is available on the CCE guide. And an applicant must either show proof that they're already serving as the conservator or the guardian, or provide medical documentation of the person's disability, including how long the disability is expected to last. This document must show that the individual is unable to manage his or her benefits. The applicant must also provide notarized statements explaining his or her relationship to the individual and who currently handles the individual's affairs. So all of this is put in place to protect the individual from potential instances of fraud. To replace a representative payee with a new one, The individual has to submit an updated application form and a letter signed by the existing representative payee confirming the end of the representation. If anyone believes that the representative payee has not been acting in their best interest, they can contact OPM, and there's a link to the complaint form in the guide. I do want to say, if people say representative payee, they also call it for short rep payee, so you might hear that word as well. Next slide. The VA has their own program, and that's the fiduciary. So the fiduciary the VA will appoint a fiduciary to manage the benefits of a veteran who's unable to manage his or her own financial affairs because of injury, illness, or age. There's more information on it in the CCE guide. To become a fiduciary, a family member, friend, or organization has to give the local VA regional office the name and VA file number of the veteran who needs the help, the proposed fiduciary's name and contact information, and a complete statement in support of appointment. The VA on their end will do their own due diligence. They will investigate the proposed fiduciary. They'll do criminal background checks, review credit reports, conduct a personal interview, get character references, all of that to protect the VA, the veteran. A veteran can appeal the VA's decision about whether a fiduciary is needed and who should be appointed. They can submit a notice of disagreement letter and provide any additional evidence showing that the fiduciary is unnecessary or that somebody else should be appointed. Fiduciaries do have to submit periodic accountings to the VA. And again, if anyone believes that a fiduciary is misusing the veteran's benefits or engaged in improper or fraudulent activities, they can contact the VA toll number or submit a written complaint. Next slide. So here we have an example for a fiduciary for veterans benefits. So Floyd gets veterans benefits. The government has sued him because he has not paid the taxes on his home. He also is late with his mortgage payments. Floyd has post-traumatic stress disorder because of his military service, and he has depression that is often severe. It makes it hard to manage his financial obligations. Floyd's daughter successfully applies to the VA to be named as Floyd's fiduciary for veterans benefits. She now monitors Floyd's VA benefits and pays his mortgage and taxes on time. So those are some examples of managing retirement accounts, Social Security benefits. Next slide.
Great, so let's talk about some other tools that exist out there that are pretty common within the disability field. And you may have heard of them, and we're trying to spread the word about them. A special needs trust is one of those tools, and it's designed for someone with a disability who receives governmental benefits, such as Medicaid or supplemental security income, but who may receive additional funds or assets that would disqualify them from eligibility for governmental benefits. Governmental benefits are dependent upon certain kinds of resource and income limitations. And so it's a way of planning ahead in the case someone gets additional funds. Special needs trusts hold funds intended to assist the beneficiary, but these funds can't be given to the beneficiary directly. Instead, a trustee is appointed, decides how to use the money to pay the beneficiary's expenses that are not covered by the governmental benefits. The rules and tax implications for special needs trusts are highly technical, and so anyone considering creating such a trust should consult an attorney who has experience with special needs trust. An improperly drafted trust could accidentally disqualify the beneficiary from receiving governmental benefits. And I'm going to tell you, I've seen it happen, okay? It really is important to talk to an attorney who has current experience in drafting these trusts when you're thinking about doing this. And so you should be asking questions of the attorney, like, when is the last time you've done one of these trusts? How many have you done? Those are all kind of very good suggestions to make. So there are some nonprofit organizations that manage the assets of numerous people through a pooled special needs trust. Each person has a separate account, but the funds are managed together to maximize their investment potential and to achieve lower management fees that would otherwise be able to be achieved through a special needs trust. You can find contact information of organizations that provide that kind of service in the CCE guide. A second tool is the Achieving a Better Life Experience, or ABLE Act of 2014. It authorized the establishment of ABLE accounts, which are tax advantage savings accounts for individuals who acquired a significant disability before turning 26 years old and who are eligible for or already receive Social Security benefits. So this is another option to consider in terms of advanced planning. And more information about ABLE accounts can be seen in the CCE guide. In the case of ABLE accounts, it's the person with a disability is retaining ownership, okay, but they're protected from it being counted towards their resource and income limitation, resource limitations, excuse me. And ABLE accounts can also be managed by an authorized representative. So please look at the CCE guide for more information about that tool. Next slide, please.
So we're gonna dive into the last option, which is the most restrictive and really the last resort. So that's conservatorship. Only a court can establish a conservatorship. A potential conservator or another interested person has to file in probate division a petition for appointment of conservator. So conservatorship, or a conservator, manages the income and assets of an individual who no longer has the capacity to manage their finances. They're not able to make financial decisions. There's no power of attorney. There's no supported decision-making agreement. They no longer have capacity, and somebody needs to manage the assets. Only a court can appoint the conservator, and it has to go through a court hearing, and there's a whole court process. The reason it's a last resort is because it removes the right to make certain life decisions from the adult, including things like whether or not they will keep their homes that they've owned all their lives. That's why it's really important to look at all the other tools before settling on a conservatorship. So the court is going to schedule a hearing on the petition that's filed. And at the hearing, the petitioner must prove through medical evidence or testimony that the person for whom conservatorship is being requested does not have mental capacity to manage his or her financial affairs. If the person for whom the conservatorship is being sought does not have a lawyer, the court will appoint them a lawyer to represent his or her interests. The court may also appoint a guardian ad litem, and that is someone who's responsible for determining that person's who's struggling, their point of view, their interest, and to communicate with the lawyer about the best steps. The court may also appoint an examiner who's a qualified professional trained in diagnosis or care or treatment to examine the person and submit a report. So that's additional evidence as to whether or not the individual needs a conservator. And the court may also appoint a visitor, who's typically a social worker, to interview the person and provide an assessment. So all of these are put in place because it's a last resort. The court wants to be 100% sure that the individual actually needs a conservator before appointing that. A guardianship, which was talked about in other settings, is also sometimes used when a person lacks capacity, even with help to manage their finances, but their assets are not sufficient enough to justify creating a conservatorship. And there's no other ways of managing their money, for example, through a rep payee, which we recently discussed. So if somebody has nobody else in their life to appoint as a representative payee, and they don't qualify for some of the representative payee organizations that are out there, like Bread for the City or Iona, or through another provider, for example, nursing homes sometimes become the representative payee for their residents, then it might be time to pursue guardianship. If the individual doesn't have a lot of assets, they don't own a house, and they have very limited income, a conservatorship may not be needed. Next slide, please. So I mentioned all the steps in the actual procedure. to ensure that the individual is protected. But the conservatorship itself includes a number of safeguards to protect the incapacitated person. So before appointing a conservator, the court will carefully review the background and qualifications of the candidates for that position. If they cannot find a suitable person, for example, if no family members pass the background check or financial checks, then the court may appoint somebody from a fiduciary panel. The conservators have to submit a conservatorship plan. So that plan has to explain which services are necessary to manage the person's property, how the conservator intends to share decision-making duties with the guardian if one has been appointed, and how the funds are going to be spent. The conservator is supposed to consult with the person who's under conservatorship to the maximum extent possible, or with the person's guardian if one has been appointed. The court requires the conservator to post a bond. So however much assets the individual has, the conservator needs to post a bond to make sure that those assets are protected. The conservator must file with the court periodic reports and accountings, identifying all transactions involving the conservatorship's income and assets. And the court requires the conservator to submit an inventory of all the income, expenses, assets, and liability, and along with the conservatorship plan. And on an ongoing basis, the court reviews the conservator's performance. So all of those are set up to safeguard the individual. However, conservatorship, the other reason it's also a last resort is it entails a number of costs and restrictions. So establishing a conservatorship usually requires hiring of lawyers and other professionals to make sure that all of the accounting is done correctly. Conservators are entitled to be paid for their services from the property of the person under conservatorship. So if the individual has a conservator because of they own a house and several assets, the conservator can run through those assets in order to get paid. They do have to submit to the court their billings as part of the conservatorship duties, but it can mean that a person who had a lot of wealth is depleted because of the conservatorship. And once it's established, a conservatorship is very difficult to undo or change. You have to go back to the court proceedings, which means hiring more lawyers and other professionals. Depending on the circumstances, the expense and formality of a conservatorship may not be necessary. As we mentioned, there are a lot of other options out there, including things like special needs trust. So if a person owns a home and is moving to a nursing home, for example, they can sell the home, have the funds put into a special needs trust that is going to be managed by those people, and a conservator does not need to be appointed because the conservator will take the money from the proceeds of the sale. Depriving a person of the ability to control his or her own financial resources can seriously harm a person's sense of security, their independence, their self-worth, and slow or prevent further development or even damage a person's decision-making capabilities or capacities. So again, conservatorship only when it's really necessary and there's no other alternatives. To change or end a conservatorship, the person under conservatorship, the conservator, or any other interested person can file a petition to the court, and the court will terminate the arrangement. The court can terminate the arrangement if it determines that either the person under conservatorship has recovered decision-making capabilities or the need for the conservatorship has ended. For example, there are other supportive services that have been found to help them. If a conservator resigns or is removed by the court, but the conservatorship needs to remain in place, the court will appoint a successor conservator. Again, if anyone believes that a conservator is neglecting or abusing the person under conservatorship, and this can be physically, emotionally, financially, in any way, they can submit a written statement of complaint to the probate court. The form for the complaint can be found on the probate's website. Probate's website also has a lot of other tools that are useful for people who are conservators to understand what their responsibilities are. And as I mentioned on the last slide, guardianships can be used in some situations. And if you are interested, or if you think somebody may need a guardian but not a conservatorship, you can watch the recording of our webinar on assisted decision-making tools for healthcare, where we discuss guardianship in a bit more detail. Next slide. So here we have an example of Miss Alice. Alice is an 85-year-old widow who lives alone in the house that she and her now deceased husband bought. For many years, she worked for the government, and she now receives a monthly $5,000 retirement annuity. Alice has always been fiercely independent and never discussed her financial affairs with anyone or trusted anyone to help her manage them. In recent months, she has been showing signs of increasing dementia. She has not deposited her retirement checks or paid her electric bill or property taxes, and she has been found walking around her neighborhood lost and confused. Alice's daughter, Janine, is concerned but has no authority to act on her mother's behalf to pay delinquent bills or to make appropriate financial arrangements for her care and well-being. Alice does not have the mental capacity to sign a financial power of attorney. Instead, Janine petitions the DC Superior Court to be appointed conservator of her mother's property and financial resources. The court determines that Alice lacks the ability to make decisions about those matters on her own and appoints Janine as her conservator. The court requires Janine to, 1, obtain a bond in the amount appropriate to protect Alice's assets, and 2, submit for its review and approval a former conservatorship plan. Upon completion of that process, Janine has the authority as a conservator to manage her mother's property and pay her bills. Janine must submit to the court an annual accounting of Alice's income, expenses, and assets. So this shows the difference between supported decision-making, financial powers of attorneys, conservatorship. As you can see with this, the conservatorship is kind of a final deal. Janine takes complete control of Miss Alice's financial situation. Next slide.
So I did see we got some questions, and one of them, Catherine, you already answered, but I will just read it so that other people might want to hear it. Powers of attorney does not include healthcare, so would that be a good idea to have a living will? And you can read your response, Catherine.
So the financial power of attorney does not include healthcare, but you can make a healthcare power of attorney. It's a fairly simple form, and I believe the CCE guide has a link to that form. The healthcare power of attorney will cover making healthcare decisions in the chance that the individual is not able to make those healthcare decisions. You can combine that with the living will, which is what the doctors are supposed to do under certain circumstances in terms of end-of-life decisions. I also put on there the medical orders for scope of treatment, which is a relatively new form, but it's a form you fill out with your doctor instead of filling out on your own. And that gets recorded with DC Health. You can add the healthcare power of attorney. You can put all those documents together, hand it over to your doctor, say, help me get the medical orders for scope of treatment, the most form, and they will record the whole thing with DC Health. What that means is when you end up going to the hospital or any emergency, DC hospitals will have that information right away. And so a power of attorney won't have to try to find the power of attorney, they already have it. And that just makes the whole process much simpler for the doctors on that end.
And another question we got was, can you ever reverse guardianship? And you can reverse guardianship. It can be a process that takes some time. You basically have to show evidence that the guardianship either is no longer necessary or that the person has regained or developed the capacity necessary to manage their own affairs without the need for a guardianship. I'm going to say, honestly, it is hard to reverse a guardianship in the sense that, it's the court that is going to be making the determination as to whether or not the guardianship would remain or not. So you really need to show the court and go into the court really prepared to show evidence that the circumstances have changed. Okay, because the judge is not going to, judges don't like to think they were wrong when they first appointed the guardian, right? They're going to need to have additional evidence that shows the person is either regained capacity, developed capacity, or that guardianship for some reason is unnecessary, perhaps because the emergency has been fixed. So those are pieces. I've seen people who have gone in to try to restore the rights of the person, and they didn't go in with all that evidence, and they didn't win. So you have to really go prepared, and we really do suggest that you consult with an attorney to try to plan that in an appropriate way so that you're using your time and your attorney's time in the appropriate way. Do you have anything to add about that, Catherine?
No, I completely agree. Courts don't like to be questioned on their decisions. And so you have to really come prepared as to what reason there is. It isn't impossible, but it just does take a lot of work, and it's better to have an attorney present. I think it's easier to get a replacement than it probably is to get it completely reversed.
And my message, though, my message on this too is, I think you're right, Catherine, but my other message is it's worth it. It's worth putting in the effort to get rid of overbroad and undue guardianship. And, you know, just to do a last plug for Jenny Hatch Justice Project, we help people on meritorious cases to do that. We also encourage people to avoid overbroad and unnecessary guardianships in the first place, or to seek kind of limited or temporary guardianship before going to the full general guardianship for that very reason.
I agree.
So it is 7:30. We are at time. Thank you, Morgan and Catherine, so much for being here tonight. Your expertise was greatly appreciated. Thank you so much for everybody who tuned in. And we really do appreciate it. There's a short survey at the end of this if folks don't mind taking it, and a recording of this webinar will be available on CCE's YouTube channel, and I will be emailing recordings out to folks. Thank you so much, everybody. Have a great night.